And we are now on the record. Today is April the 9th, 2025. I'm Sharon Bernardi, and I'm joined by my fellow board members, Ms. Deborah Dobkin and Mr. Fred Lauer. And this is a public deliberation being convened at 9:30 a.m. by the Baltimore County Board of Appeals in the matter of 19A Newport Drive, LLC, legal owner, Evans Funeral Chapel. Case number 24-076-SPH for property located at 11543 Philadelphia Road in Baltimore County. And this deliberation is regarding a petition for special hearing for an extension of a special exception approval for a period of not more than 5 years from the date of a final order that was granted pursuant to BCZR section 502.3, and the hearing was held on March 5th, 2025 before the County Board of Appeals. And we have several issues before us today. And if you agree, would like to just state what I see the larger issues are. And if I leave out something, please let me know, and we will include that in the list. And then we will go and give our position on each of the issues as we deliberate. And the first issue that I felt was before us is whether there is an issue of res judicata that would collaterally stop the petition filed by the petitioners. In the memo that was presented, petitioner also addressed whether there was a de novo hearing that we held, which I think we can dispose of that without any discussion. Be stated on the record that the hearing was de novo pursuant to Baltimore County Code. Was the petition filed timely? And then, of course, the substantive issue of whether the petitioner should be granted the special hearing as requested regarding the extension. Are they the main issues that you also see? And if I left out something, please let me know so I could add it to the list.
I don't have anything else. Thank you, Madam Chair.
Thank you.
Nor do I, thank you.
Thank you both. So I'll begin with the first issue. And regarding the res judicata issue, the protestants, I saw that they were arguing that the petitioner should be equitably stopped from filing this petition because they felt that doing so would revive or extend the original petition that expired on May the 16th, 2024, and that in essence to do so would allow the petitioner to get a second bite at the proverbial apple. And they cited, it was Lippitz, I think, v. Hurwitz as their authority for this because they felt that the petitioner conduct was voluntary, that the petitioner intentionally did not disclose the plans of the crematorium on premises, and that they relied on the conduct of the petitioner, and that reliance led to their detriment because they did not protest the original petition. And the petitioners, argue that they're not relitigating the issue, that they are requesting an extension of the 2-year limit that was provided in the original order by the ALJ, and that they have the authority to do that under BCZR section 502.3, which would give them up to 5 years, so long as, and I would just quote, that the construction is commenced while the special exemption approval is valid and thereafter pursued to completion with reasonable diligence. And in this case, the construction had not begun, but they, within that time frame, requested a temporary extension from the ALJ for 6 months, and that was challenged by People's Counsel. The form in which they made the request was challenged by People's Counsel, and that's why they filed the special hearing request. And I personally feel that ALJ determination clearly explained why there was no race judicata and that they should not be collaterally estopped because she was not hearing or relitigating the original grounds of the original petition, but in essence, just determining whether or not an extension should be granted under the county code and regulations. And would love to hear your positions.
I agree with you. I think People's Council challenge was purely procedural, not substantive. And I think we are really just looking at the reasonableness of the extension, and the ALJ got it right.
I agree also, Madam Chair and Ms. Stockton.
Thank you both. And as I mentioned, the second issue about it being de novo, I don't believe we need to discuss because it is just as a matter of course. Regarding whether or not the petition was filed timely, I know the protestants were challenging that, saying that, you know, it expired May 16th. And I want to look at some of the chronology here. Evans submitted the letter requesting the ALJ to extend it on March 7th, and it was initially approved on March 16th. And from my analysis, it appeared that all the dates were prior to the May 16th deadline. And so I don't see that there was an issue in the timeliness of the filing of the petition.
I did not find an issue there either.
Nor did I.
Thank you. Now it gets on the reasonableness of the merits of whether or not the extension should be granted. Again, the protestants are arguing about the delays that took place in this. They were alluding to the petitioners, I guess, not fully disclosing their intentions and waiting to record the plat, and they felt that this was not done with full transparency and that they shouldn't get the benefit of that, and therefore it wouldn't be reasonable for them to be allowed the extension. They felt that they were trying to circumvent the CZMP process by waiting until 12 days before the special exemption expired. And there was, you know, testimony from both sides. I felt that supported the petitioner in that he was doing all that he could within his power to move this along, and that there were delays of the county for which he didn't have control over. I mean, there was some discussion of whether things could be done concurrently to help move things along, but I also believe that from what I heard, the testimony is that it's not efficient to do that because you had to get all the reports in from the various county agencies, and depending on what was received, other agencies may amend their reports. And so it's a common practice to wait until you have the complete information prior to making your final response. So I believe that petitioners would have preferred for this not to have taken so long, and that he was trying to manage the county and the process as best he could, and waited until he had no other option but to request an extension of time.
I agree, and particularly looking at, I believe it was Petitioner's Exhibit 6, the exhibit from Macmillan of Carroll Engineering. And, you know, as you go through it, you see all the various comments, submittals, resubmittals, documents required, etc. it appears to me that that's, and it was very eye-opening in some ways because I've never really gone through that process myself of submitting those documents. And the frustration that was evidenced by Mr. Evans himself when he got up there and talked about this. And this is almost 3 years of submittals and resubmittals and requests and documents, et cetera, et cetera. And it appears to me that they acted in good faith and trying to move this along as best they could. And I wish there was something more we could do about the timing, because recently I had another matter regarding the same thing, not the same type of establishment, but the extension of time and how long it takes to get through the process, and finding that many people have that problem, and perhaps there's some way to address that. But I would agree with you completely, Madam Chair, that this petitioners have proceeded with due diligence in good faith, and I don't see any reason why not to extend them to the 5 years that is the maximum allowed here.
And I would agree with that. And I think it is worth noting that the petitioners wisely got a plat recorded to help protect their position. And the plat was timely recorded before the zoning changed, which vests them under the code. It's pretty clear language. It's slightly different issue, but goes to the same result. So yeah, I would agree with you and Mr. Lauer.
Thank you. And I guess one other is not an issue, but I just wanted to maybe get on the record that we deliberated this, as well as it just came to mind is that the protestants were, I guess, challenging or questioning whether or not there was notice that a crematorium was going to be on this particular property. And I know that was addressed below, and there was discussion at the hearing. And I feel that evidence was presented that the signage on the property was notice to the protestants. And I mean, we may or may not have to deliberate that, but I just want to make certain that if that was ever an issue, that we did at least have our position on the record.
And to add to that, I think that it was also articulated at the hearing itself and in the decision. And that whatever happened preceding that, and there was conflicting testimony. So it's hard to know for sure whether he said, she said, all of that. But what came forth under oath at the hearing below really should be what we rely on. It's in the record, it's in the order, and it was available to the public both to attend and in reviewing the order. And I think we cannot look behind that.
I agree with both of you. Petitioner's exhibit number 12 is the one that kind of stuck out to me, and it clearly says that there's a crematory there in that particular exhibit. And as you said, Ms. Dobkin, there was conflicting testimony about whether he said, she said, whether the crematory was or was not included. But I think the documents themselves, if you look beyond just whether he said, she said, if you will, that the documents themselves and the filings have all been clear that it was a crematory included in the filings before everyone since this began in 2022. So I think the record shows that the plans have been for that, and I think that there's no reason that we would look beyond that. So that's my thoughts.
And I agree with both of you, and I see we don't have any other issues. We definitely want to thank both parties for their professionalism and preparation for the memoranda that they provided. And we are in full agreement to uphold the order as de novo, so we will issue our own order, but we agree with the decision that was made below.
Thank you.
Okay, thank you.
Thank you.